calling from Los Angeles, and I'm having a little problem under the name ThatUmbrellaGuy. I sent him my phone number at least 20 times in the chat and told him to call me. He ignored me. I'm a man. I filed the report. If you guys could take a look at it and give me a call back, I would love to hear what you guys can do to help us. We really need to kind of stop this guy at least until Monday. I told him to call me. I'm a man. I'm a man.
All right. Hey there, to all you wonderful folks. Welcome to a Sunday edition where we continue the fun into AH versus her own team. Now, this actually is getting to the good parts too, because this is getting into the potential for it going forward into actual trial. I mean, this, I never expected. Give me 1 second. I never expected all of this stuff to turn into what it has. And yet it keeps getting more and more interesting. And right now, if things go forward the way that they look like they may go forward, we may end up right now we're in the middle of crazy anyway. If you haven't seen this, I'm going to pull it all up just to show you what it looks like. But essentially, if you want an idea of crazy, this is how it's gone. You have AH lose her trial. Then you have insurance company number 1 sue insurance company number 2. Insurance company number 2 countersues insurance company number 1. And AH countersues insurance company number 2. And it's all just an amazing, crazy, fun time. I mean, it's so interesting. So I'm going to pull up some documents just to show you. I want to go through this new filing just to show people again. I want you to see it yourself and to know where everything is. I also want you to understand, too, that this has the real potential of becoming a trial, like a very real trial. And both parties that have been involved in this, they want there to be a jury trial. So if we get a jury trial, that might get really fun. Carol, thanks for the 2, by the way. Tug, just thanks, mods, and much appreciated. Thank you. I saw a few gifted memberships too. Let me catch those real fast. Fallen Hero, thanks for the gifted membership. Thank you for that. Hey, what's up, Rachel? Like to see you live again. Yeah, you need to keep an eye out too, because in the last 5 days, YouTube has just ghosted live streams here. We went from 1,700 to 400. Nobody's getting told. I get people all the time afterwards saying, I didn't know you were alive. And it's like, okay, well, Keep an eye out for this time. That's the best way to do it. And Sepsi, thanks for the gifted membership there. I mean, it's been nuts, though. This is one of those subjects that they can't really decide if they want you to cover it or they don't want you to, but I don't care. I'm going to cover it anyway because it's fun. All right. So we start out, again, like I said, just giving you a brief overview, making sure people understand all the dynamics to this. Of course, this starts 2021. And you have the kickoff of fun times with Travelers Insurance. You have all the filings that come with this. There's quite a few of them that come up with it. You can see it all traveling through. You have quite a good stuff. If you haven't read those original filings, how that comes together, I mean, it's interesting. What you have essentially, just again giving you the overview of this, you have one insurer suing the other. Remember when AH said, "Hey, I paid X amount of money. I paid, what was it, 8?" Well, she said in court, her lawyer said $6 million. They actually end up paying out $8 to $15 million all told, somewhere in that ballpark. And it wasn't AH paying, of course. It was insurance companies, which we find out later. One insurance company was told, "Hey, you're not pulling your weight." That would be New York Marine. New York Marine. I'll say New York, Maine. Sometimes you have to excuse me if I do that, but New York Marine, they were told they weren't pulling their weight. They needed to pay what was due in this. And they were like, "Yo, I'm not paying that." Why? Because unclean hands. Now, if you don't understand what unclean hands means in this, I actually think that this is kind of a fascinating discussion in it, because New York Marine, here we go. So New York Marine, give me 1 minute here. There it is. New York Marine has filed a few things on this, but when they talk about it, they talk about the idea of unclean hands, meaning they had representation that they paid for. They paid for specific lawyers. They were like, "These are going to be our lawyers in this Travelers Insurance." They had lawyers that they had greenlit as well. And AH didn't seem to like certain lawyers. In fact, she decided to cut them out of litigation altogether. A lot of these people at first, of course, they're okay with it. Why? Because they think that this is going to be their gold mine opportunity. Well, it doesn't turn out to be that thing. Of course, they lose. When they lose, there's not clout to be shared. There is blame to be shared. And it leaves a lot of damaged people along the wayside. This has been all lawyers have problems behind the scenes. I'll tell you, all lawyers. I mean, whether that's debt lawyers, there's going to be some animosity behind that too. Like, just to be honest, they all have problems on cases because they're human beings. You're going to have people that feel slighted. You're going to have people that are cut out and so on. But typically this doesn't pour forward. You don't see it pouring out into the public. And in fact, I don't think AH thought any of this would be seen at all. That's why when the unclean hands thing came up, there were quite a few lawyers that were involved in this. But AH, according to New York Marine, made this concerted effort to cut out their lawyers that they wanted. She went out. She cut them out intentionally. They wrote them out of the lawsuit to the point that they considered themselves not part of the case anymore. So again, they back away. Now, again, AH, if she would have won the case, we would probably be talking about something totally different. We're talking about like a totally different case altogether. But she didn't. Again, then the lawsuits fly. And part of that answer, again, you have one insurance. I'm going to call these people Insurance Company 2 when I discuss it all the way through. That'll be New York Marine, or I'll just call them Insurance Company or the insurer or whatever when I'm talking about them with AH. So again, you have Insurance Company 1 sue Insurance Company number 2. Insurance Company number 2 counterfiles. They say, "Nah, we're not going to do that." They also go after AH in this. When they file, of course, they're saying, "We're not going to pay." They go after AH. Well, AH decides she's going to counterfile against them. And you can see like how this starts out. versus, of course, she's suing for money against an insurance company. And insurance companies, here's a little thing you have to understand about insurance companies. They have money to burn. They have lawyers on retainer. That's what they do. They are the law. They know the law. And when you go after them, I mean, this is what they're built for. They're built for going after people, but typically you don't see them going after their own clientele. The thing with though, as they're saying, they don't have to pay because again, unclean hands, and also this little thing we call actual malice. I'm trying to pull something up here. It's being slow. Give me 1 second. Pulling up a date range for you too. I want to show you something. DUI Guy and Laura B have done an excellent job talking about this subject as well. I want to give them both shout outs for this. Laura B does excellent breakdowns of every single piece that comes up in this. I do sometimes here and there. I don't want to cover every single item. I want to cover the items I think are of interest, but I'm not saying that those items aren't important. When I say that, I want to make that very clear. Every item in this, when you're moving forward, is indeed important, but I'm sticking to the stuff that is it. We're not talking about delays or anything like that. But Laura B, again, if you want a real breakdown, telling you every single thing that is involved in that, yeah. So we have date lines on this too. As this moves forward, again, when we get to this portion here, we have, of course, our filings. Give me a minute. Give me 1 second. We have our filing by New York Marine. New York Marine, I think this scares AH. The reason I think all of this stuff here scares AH is because the idea of unclean hands, that would involve her lawyer. You can see this noted right here. New York Marine is informed and believes that okay, wait. Let's start right here. Okay. I want you to understand what's being claimed here, what she's counterfiling against. Again, I want you to understand the problem with all of this. And this is very real. This has been going on, but a lot of people, they've tuned out of the AH crazy, but the fire in the aftermath is amazing. I mean, it is amazing. This is the best part of it because, again, her own team has started eating each other. You have Elaine. Elaine finally made a public appearance. She made a public appearance in I think they call it the lawyer's prom. I'm looking for footage of it, but I haven't found footage itself. If anybody has the footage of that, send it to me. I saw posts about that. This is actually why it's important too, because you have a lawmaker, a politician that has been sharing that. A politician, a powerful Democratic politician that has been sharing and talking about, the bullying that Amber Heard's team that they faced. And I was like, Elaine? You mean the person that just drug in random people, that went after people in some of the nastiest ways possible? That person, they're going to complain about it. They're doing the same broken record deal. And that's expected. But what's messed up is, again, this rewriting of history. And on top of it, lawmakers getting involved. What you have is a two-pronged offensive right now, really three prongs. You have the payback offensive. You have people singled out and targeted for their portions of this. You have like Dr. Muffins, for example. You have Raven Simone targeted. Again, they're working their way back and they go after everyone. That's one prong. Second prong, mainstream. They rewrite the entire case. They've been doing it from go, but they're trying to convince everybody that, this stuff, it wasn't what you saw. It was actually some kind of miscarriage of justice. You didn't know it because when you were watching it, you didn't realize what the truth was, but they'll tell you because they're the arbiter's truth. Third prong of that is getting law into place where you cannot talk about this stuff. You can't challenge these things anymore. They want to make it law. They want to circumvent First Amendment protections. And they want to make it where this kind of stuff is, quote unquote, hate speech, unless you're somebody that they sign off on. Again, if you're an arbiter of truth, and you can see platforms turning to this too. That's why when you go on YouTube, for example, and you search the Idaho case, you'll notice something. If you went Idaho killings, you do this. Here's you a wonderful test. Sign out of your YouTube. Have no data, nothing backing that up at all. Nothing to pick up anyone that you watch. Just sign in from an incognito with no cookies, no nothing. Sign in and search. You won't find a YouTuber. You only find approved choices. The very thing that drove people to alternate platforms learned that game, they're obsolete now. So they're taking over those platforms. And those platforms are, of course, letting them because they pay. It's the same thing you'll see on Twitter. Like I was saying the other day, Warner Brothers, for example, let's just take Warner Brothers. Warner Brothers as a company pays $1,000 a month for a gold check mark, plus $50 per every account that they add under it. So Aquaman, it has a gold check mark too. That costs $50 plus. So you're talking about a company spending $13,000 a year. You got the 12 plus. So I'm just going to call it 13, although they may go well above that, versus people that don't pay a dime. Who do you think they side with? They buy you out of being able to talk about this stuff. They rewrite it all. While that's going on, again, the real story, though, is, you see the self-destruction, the chaos that has happened in front of everything with everyone eating each other. And it's because of things like this. Again, and we'll get to our new piece. Again, I just want people to understand what's here. So on October the 1st, 2019, New York Marine accepted AH's defense of the underlying action subject to a reservation of rights. Specifically, New York Marine advised Heard the New York Marine would provide a legal defense, but that to the extent California law does not permit an insurer to indemnify the insured, no indemnity could be provided. At the time tendered the underlying action, the law firm Cameron McAvoy, that's somebody you may remember from way back when, was defending in the underlying action. When New York Marine accepted her defense, they agreed to continue the defense of with law firms. So they wanted to continue with that specific law firm. That's the one that they signed off on. This is where your unclean hands thing comes from. New York Marine is informed and believes that on such information and belief alleges that or her agents instructed other firms defending in the underlying action to not include McAvoy in AH's ongoing defense. So you notice that. Again, they didn't quit like everyone thought. They were just phased out. As it says here, she or her agents instructed other firms, the other places that were part of this lawsuit, to not include them at all. When it says that, what they're talking about is, and you can see this actually in documentation that comes up from that time, which is fascinating to go back and look at. If you look at the actions as they move forward, you'll notice they're not included in emails that come up. They're not included in anything. They are phased out. Well, New York Marine is like, yo, that's who we chose. And it's strange how tries to fight this thing. She can't deny that they did it because it's on record. So in her new filings, she admits to this thing existing, but so as a result, on or around November the 2nd, 2020, McAvoy ends up withdrawing because of that. So you have your trial, of course, everything that happens with the trial. And again, word of the day, as many people have noted, actual malice. Hey, what's up, Mike? Thanks for the 5. Hey, Tug, I sent you an invite to tonight's episode of the Mike's 10 Week Edition. Did you get it in your email? I don't know if I did, Mike, actually. Let me see. Yeah, I just got it. Yep, I did. I hadn't seen it before. I thought you might have sent it earlier. Yeah, I see it in there. I'll see. It depends. We started, my daughter and I started the game Horizon. What is that new one? It's on PS5. It dropped down to we've had the copy for $30, and I just played the other one. I'm like, man. So me and my daughter were playing it together, So we'll see what comes up with that. But man, I love playing video games with her. So I'll just see. No. Hey, Marie, thank you for the 10 gifted memberships too. It's cool. Like right under there, I watch those fall in. Awesome. And John, thank you for the 2 and the thumbs up. Thank you. So you see how this comes together. Again, you understand all of that. And again, props to you all. I don't mean to minimize. If I say that, I really do appreciate your backing there. But you see how this plays out. You see everything that comes up. Yeah, they're saying we don't want to pay. So comes in with a counterclaim to that. Oh, you notice too, here's another thing that I don't know if it's been stressed before. Here's another part of this. I just do want to stress this as well. You'll notice in this complaint, they wanted a demand for jury trial. Now, I think, gets the big flex. She's not going to eat this money. Now, she was in trouble when JD had her on the ropes. I mean, she was breaking down because of this. For real. If you read no joke, if you read the filings from that time, she was having an actual breakdown. Her lawyers were saying, hey, can we pause all of this until we get this thing resolved? Because again, the stress and everything else, she was not handling it well. And it's fascinating there because this has been a disaster of her making, whether it's JD that she's gone after, whether it was all of the issues that she's had with insurance companies. If you look at the reasoning behind it, this again has been a disaster of her making every single time. And yet, her career falling apart. And it's funny too, just a note on that. There are people that, I bring up blacklisting, for example, and there are people who disagree with blacklisting. They say, no, there's no blacklisting that umbrella guy. Yeah. What do you think happens after Aquaman 2 fails? What do you think happens? Especially considering all the stuff that's going on right now, how the heck is it going to succeed? I mean, really, some people believe that all press is good press. Nah, not so much. So what happens when that fails? When you are the catalyst for bringing down not one, but 2 multi-billion-dollar franchises? Because you look at the Harry Potter stuff. Harry Potter, great success. Harry Potter games, great success. All of that stuff. Oh, it's doing great. Fantastic Beasts flops. The last movie flopped hard. Wonder why that happened. Could it be because of the replacement of JD? Because of all the issues with Ezra Miller? And of course, that certain lady that's been attached to it. So again, yeah, what do you think there? But she gets a reprieve because JD wants to settle. I have this sneaking suspicion that over time we'll hear more about what motivated that too. And I'm curious how that'll go, but I get this idea that we will hear more about that as it moves on. Hey, beautifully, thanks for the 2. Sent you something that explains so much. I'll check it out. Send it to my email, make sure, and put it right at the top if you would too. Mike, thanks for 5. I hope you'll join our panel. So I always look forward to get your input on all things niche, especially comics, since that is your field of niche. I'll check it out. If not, I will get on there one day this month. Okay. I'll make it within the next month, we'll say, within the month span that comes up. I'll make sure that I do. Because we need to just hang out one day, talk a little bit about whatever comics. So anyway, you notice jury trial was demanded by them, and appreciate you, Mike. Well, of course, answers this. Of course, she's going to answer this. Her counterclaim comes in, and you've got to remember what was fascinating about this is that when the counterclaim comes in, she brings up the idea that she wants a jury trial. You see that right here. Now, this is interesting to me because this is the same person that shouted down our legal system. Now, again, when I say that, I want to be very clear about something. The legal system is flawed, very much so. And in fact, I don't really like trusting a court case that I don't see or examine. That's one thing. I'm running into this issue. I'll report what goes on with something, but I don't trust the arbiters of truth out there. So, yes, I agree that the court system has huge flaws. I believe law enforcement has huge flaws, but we saw this case play out with our own eyes. That's the issue. So she shouts it down when she does when she talks about her settlement. She gives all of these reasons. One of them, of course, is her decrying that whole system. She couldn't get a fair shake, and yet she's turning around and saying, "Hey, by the way, I demand a jury trial." Isn't that interesting? Now, her answer to all of this stuff, it's fascinating because she admits a lot of things in this filing, which we're going to look at the answer to this filing. That's where we are right now. But in her claims, she brings up a lot of stuff that basically tells you, amongst other things, according to New York Marine, that she's misrepresenting arguments, that she doesn't understand, or she's misrepresenting their place. And again, as it ends, demand for jury trial. Beautiful stuff, huh? Hey, Mike, thanks for the vibe. I keep sending invites. I'm sure it'll prove to be a nice break from the mainstream media baloney. There's always stuff going on in the world of niche. That's very true too. Yeah, I mean, sometimes I like the chaos, but sometimes I agree. All right, so we get to our answer for that. Now, what's fascinating, and you'll notice this on these filings, is we have something here. We have a date for all of that set with our judge. He's actually going to rule on this. Now, AH's arguments are essentially arguments that, let me roll down and then we'll roll back up. AH's arguments are arguments, give me 1 second. I want to find you a specific paragraph, just 1 minute, that have already been discussed. Like, that's one thing that a lot of people don't understand. The arguments that she makes are arguments that the judge has already ruled on, but he ruled on it. Here we go. Right here. Just give me a second. I'm locking in on a specific portion. So the arguments that she makes are arguments that have already been ruled on by the same court. It's just with a different party involved. The insurance company one that I talked about, or A. Yeah. So she's basically recycling an argument that the judge has already been like, yeah, that ain't going to fly, which I think is really funny if you read this part. Quote, "This court previously addressed the same issue and argument, albeit raised by a traveler, as it correctly concluded that because Virginia counsel, originally selected by her prior to her tender to New York Marine, had only her as a client. No conflict of interest," that's a big thing that she brings up, "giving rise to a right of independent counsel arose. So there is no conflict of interest. So one of her main talking points has already been shot down. That's a problem for her, and a big problem at that. Also, if you talk to other lawyers, if you gauge their commentary in it, they will tell you. I'm not saying me as a lawyer and other lawyers. I'm saying if you talk to other lawyers, you get other opinions outside of the documentation. That's what I mean there, just to make that clear. They talk about how shoddy the legal arguments are here. Her arguments, they get decimated. And we've seen this before, whether it's been, with AH in her appeal, for example. I mean, everyone talked about how shoddy those arguments were. And they were weak arguments, weak sauce arguments, But she has, give me 1 second, she's continually gone back to them. Why? Because she doesn't really have a case. Like Laura B states, though, and again, check out her channel, very much so. I want to give her props. But she noted the answer is essentially that they're saying, we funded a defense. This is Laura B. This is how she puts it. We funded a defense per our insurance company and had no control over what AH or defense team decided. If you don't like the outcome, then ask AH. We're not responsible for what AH instructed her team. And that's pretty much what gets said in a nutshell. They're like, yo, and she doesn't understand the rules, the rights that she has. She thinks that she's entitled to do everything and that they have to pay for it. And that's not the case. That's not how this stuff works. And they pointed out very clearly, if you want our money, you should have played the game the way we wanted you to play, the way that you would have won. And, This case was a hard one to win, just to be honest. Very difficult. There's all these mainstream shills that are out there saying, oh, he won because of his popularity. He won because of this and that. No, he won because his team got in there. They were strong when they needed to be. And AH's team was a bunch of blithering idiots. Over and over again, just blithering freaking idiots. They kept dropping the ball. Oh, they dropped it so much. By the way, apparently AH and her simps, they don't like being called idiots. Did you know that? I didn't realize how much that made them mad. If you call them morons and stuff, every time I call them a moron, they try to report me on something. I mean, seriously, check this out. Just as a not really a side, but to work it in on that point. Check this out. This is funny, I thought. So on Twitter, I was making them. I was like, simps are absolute morons. They kept saying, "Oh, that real guy, he was getting paid by Adam Waldman." I was like, I didn't need to get paid by Adam Waldman. I've been monetizing you idiots. And they were like, "Oh my God, report." And Twitter's like, "Nah, you really are idiots. You're morons." And you did get played, suckers. Oh, a bunch of idiots. Alec, thanks for the vibe. Do you think AH wants a second season on Long Crime Network, as she never made a second season on TV with anything else? That's actually really funny. I like that. Hey, what's up, Gil? Thanks for the tip. Can we get respect and prayers for Fisty in chat? Fisty? Is that for real, or are you making something up, man? I never know if you're trolling or not. If there's somebody that needs thoughts and prayers in the chat for real, keep it with them for real. Seriously. And if Gelth is trolling with that kind of stuff, a blight on your toes, son. Let me get a drink. I had to get a drink there. So New York Marine says, AH, she wasn't entitled to independent counsel. Essentially, you don't get our money and get to go and do whatever you want. This is pretty much it's a very good, very straightforward argument. Undisputed in Heard's opposition is that an insurer's offer of a defense under reservation of rights only, quote, permits the insurer to decide whether to accept the insurer's terms for providing a defense or instead to assume and control its own defense. AH's counterclaim, that's what all of that's saying, alleged that she did not fully accept the defense proffered by New York Marine because it was impossible to do so. And her opposition confirms that she was not required to accept the defense offered by New York Marine. Heard's opposition further confirms that her alleged entitlement to recover quote-unquote defense costs, my Lord. I kept saying that in video. I have so many, you'll hear, like if I ever played clips, every now and then a clip where I mess up will get in. And only one time has the response after it, because there will be profanity after every time. I'll be like, defense costs. I'll be like, you're here. If I've done it a bunch, I'll be like, so if you ever hear a cut like that, well, I kept doing that for some reason. Consisting of expenses without New York Marine's consent is likewise based on New York Marine's own alleged breach or failure to provide independent counsel. Thus, AH's entire opposition on New York Marine's motion is predicated on the erroneous assertion of an entitlement to independent counsel. So again, that's her whole claim. If you don't understand that in layman's terms, she wants them to pay. She's saying that they breached contract, but really, she admits fault in a few ways here. She can't dodge what she did. She doesn't want this stuff to go forward, period. She's really trying to, I think she's trying to thrash about because she knows that they could destroy with what they know behind the scenes. So with her thrashing about and throwing a temper tantrum, maybe, just maybe, that would help in some way. Because again, she admits to all kinds of things, but again, she says somehow in some way, she gets independent counsel. And as they said, she you listen to what they're agreeing. It permits the insured to decide whether to accept the insurer's term for providing a defense or instead to assume and control their own defense. So she's like, okay, A, regardless of which state laws apply, Hurt is not entitled to independent counsel. Now, this is part of her argument. Well, state. And they're like, no, it doesn't matter. No matter the playground. So whether California or Virginia law apply to New York Marines, contractual defense obligations is immaterial. Its appointment of Virginia Defense Counsel did not create a conflict of interest since, 1, regardless of the jurisdictional laws govern its contractual obligations, Virginia Defense Counsel's obligations to both AH and the insurer were governed by Virginia's laws and ethical rules. So again, it's governed by Virginia rules. Under Virginia's laws and ethical rules, Virginia's defense counsel never operated under a conflict of interest since they only had one client there. Who was that singular client? Let's think about that. Oh, yeah, AH, of course. Now, Hurd argues that a conflict of laws analysis is required, that the governmental interest test requires application of California law, and then under California law, New York Marines' reservation of rights gave rise to a conflict of interest. Now, I like how this is always an insult, and it comes up every single time when anyone counters AH. They call her arguments expansive. She casts this wide net. She goes for the quantity approach rather, but not the quality approach. Her expansive arguments fundamentally misconstrue insurers' position, misapply relevant law, and flatly ignore that under California law, a Virginia attorney appointed by the insurer to defend an insured in Virginia, even under a reservation of rights, does not have an ethical conflict triggered and insured rights to independent counsel. This court, again, previously addressed this same issue. So this has already been addressed, like I was saying. An argument, albeit raised by travelers, and correctly concluded that because Virginia's counsel, originally selected by AH prior to her tender to New York Marine, had only her as a client, no conflict of interest given rise to a right of independent counsel arose. So again, already noted, and you see when this was noted, bam, so it's already been talked about. Whoopsie, whoopsie. I guess they messed that one up, Yeah. Somebody noted if you like drink and drive, insurance won't pay. Yeah, I mean, there's, that's the argument, the actual malice argument that comes up with stuff too. But see, she's trying to do this dance. She's trying to bring up the idea, well, really, I should have had this because, and they are destroying that. With respect to her contention, that application of governmental interest choice of law test alters the analysis. Under that test, the court is only required to compare two jurisdictions' competing interests after first determining that there was a true conflict of law because the substantive law of California leads to a different result. Here, there's no true conflict between the laws of California and Virginia with respect to the duties owed to the insured by a defense attorney appointed by the insured liability insurer in an action filed in Virginia, even if the defense is under reservation of rights. So they're saying, when you compare that, that doesn't really come up, does it? Both California and Virginia have legal and ethical rules in place to protect insured from defense counsels being subject to conflicts of interest. In California, because of the judicial recognition of the existence of tripartite relationships, so you have, and again, they'll explain what this means, pursuant to which defense counsel represents both the insurer and the insured, that relationships must give way in the event of an actual conflict of interest, thereby allowing the insured to select independent defense counsel, albeit an express written waiver authorized by, and they note the code. This code will actually come into play in just a little bit. In contrast, Virginia courts have altogether avoided this entire issue. They've avoided it, period, by declining to adopt tripartite relationship doctrine and instead concluding that even where defense counsel is appointed and paid for by the insurer, the defense counsel only has the insured for the client. So again, very point blank, no conflict of interest because you're only representing one person there. You only have a party. Again, there's no conflict, therefore. As such, since California law requires giving the insured the option of appointing independent defense counsel in situations where the counsel originally appointed by the insurer is subjected to a conflict of interest, no conflict can exist here as a matter of Virginia law and ethical rules. There's no true conflict between the laws. So, yeah. Nor do the case cited in her argument, they don't mean anything. So I'm going to skip some of these. Here, I'll let you, I'll ask you this in the chat. Would you just, if you want, we can go through the case citing and we can tear them apart, or you can just go with, here's the cases. They all, basically, they aren't about what she's saying they're about. We can go over every one of them, or we can just skip over those and say, yeah, that's what they mean. I'll let you vote on that. 1, you want to go over them all? Say yes. 2, we'll bypass them. So let's see where that goes. Hey, what's up, Chungy Show? Thanks for the 5. Are you going to save this? I missed parts doing IRL stuff. Yeah, I'm thinking so. 2 more ones. Actually, there's quite a few bypasses. Look, if you want to look this document up itself, again, she cites. We'll go over. I think there's multiple cases. I'll note a couple, and that way you get an idea for what she's arguing without having to go over pages and pages and pages of arguments. Okay, I think that's the best way to do it. So let's go over a couple, and that'll give you an idea of how she goes. So first, she cites Northern Insurance versus Allied Mutual, contending that it holds when the law of one state would require an insurer to provide independent counsel to fulfill its duties to defend, but the law of another state would not. It raises a conflict of law issues about the scope of the insurer's duty and that the ethical duties imposed on defense counsel in the state the defense is provided in do not foreclose the possibility that a conflict actually exists under California law. Now, she relies on Allied Mutual for the conclusion that applying California law did not harm Washington's interest and that Washington had no specific interest in having its more lenient standard apply, such that the insurer should have provided the insured with independent counsel in the Washington litigation. Now, as an initial matter, Allied Mutual actually applied the restatement's substantial relationship choice of law and thus did not in any way address California's governmental interest choice of law as advocated by AH. Further, AH's opposition incorrectly asserts the character Allied Mutual analogous to the dispute here. She asserts neither Washington nor Virginia recognize the tri-party relationship such that defense counsel represents only the insured, not the insurer, and owes the duty of loyalty to the insured that has no exceptions. What the opposition fails to note, however, is that although under Washington law, defense counsel may represent only the insured, Washington law also expressly recognizes that the insured is a quasi-fiduciary upon whom is imposed a heightened duty to insured carry enhanced obligations, the breach of which can subject both insurer and defense counsel to tort liability. So they go over how that sets up. In contrast, neither California or Virginia law imposes these rules. No heightened duty on an insurer. They don't have that. An insurer is not a fiduciary, it notes in this here, and owes no obligation to consider the interest of the insured above. And they give another case study with that as well. Furthermore, as explained in detail in New York Marine's, give me 1 minute. I'm drinking a lot of water today. New York Marine's motion. It is effectively admitted by Heard, whose opposition does not contend otherwise. Virginia simply avoids the conflict of interest, like they said before. So that's not even there. This undivided loyalty is so complete that the insurer appointed defense counsel can even turn around and represent plaintiffs in actions against other insured or the same insurer. Since Virginia law, unlike California law, requires the appointment of defense counsel who only has duties of loyalty to the insured, and unlike Washington law, imposes no additional heightened duty on the insured or counsel, Virginia defense counsel appointed by New York Marine was never subject to conflict of interest. So you see the problem there. This is what they're bringing up in here. They're saying, yeah, you cite case law. It sounds all well and good, but the places where those case laws exist, they actually have additional components. These components, they are not part of the law. When you get into California, when you get into Virginia, I mean, it's very cut and dry, they're saying. So all of these other case cited, again, other sites, like she brings in these other ones saying that they're supposed to be about, and they break them down. There's quite a few. Yeah, there's quite a bit that's spelled out there, but that's what they're telling you. So when I'm skipping over this, they're hammering that point home. They're saying essentially, yeah, it looks all well and good on paper, but again, she made an expansive argument. She wasted a lot of paper. But what does it really say? And we've seen that, like I said, we've seen that repeatedly when you're dealing with AH and you're dealing with litigation. They bring a whole lot of nothing. They fill up a lot of pages, but what are they really saying on said pages? So the application of civil code, 1646. So setting aside the general choice of law analysis, the opposition also addresses the application of civil law 1646 at length. To this end, the opposition argues that New York Marine's policy does not expressly specify a place of performance, thereafter asserts that 1646 compels the conclusion that California is the place of performance for purposes of choice of law analysis. According to her opposition, again, you get Frontier Oil Corp versus, in the place of performance is not explicitly identified, then it can only be determined based upon where the insured enters into the contract. Heard further argues that the place of performance therefore must be California because, quote, it was not foreseeable that an action would be filed against her in Virginia, and therefore there was no intent that the place of performance would be Virginia. However, the issue of AH's entitlement to independent counsel is not one of interpretation of a contract, and thus this code, it has no application. So her argument here, that doesn't apply as well. Neither her counterclaim nor her opposition asserts that any particular term in New York Marine policy should be interpreted differently by virtue of California law. Furthermore, even assuming that we apply 1646, the recent California case law hold that a place of performance for the purposes of section need not be expressly specified or stated by the contract, but rather can be gleaned from the nature of the contract and its surrounding circumstances. Thus, in applying 1646, California courts have long understood that where a multiple risk policy insures against risk located in several states, it is likely that the court will view the transition as if it involves separate policies, each insuring an individual risk, and apply the law of the state of principal location of that particular risk involved. So again, she tries to claim one thing. She tries to say, well, what about the application of this? Because California, and it's like, no. It doesn't matter if people thought it was going to happen in California. There are laws in place for that. Her attempts to undermine applicability of this well-established principle on 3 cases. So she gives 3 cases on how she does that. I'll give you one. You get an idea of how this comes together. So in James River versus Meadowlark, Labs, the count found that where James River was called upon to provide a defense, the California litigation for its Oregon-based insured under a policy to the insured in Oregon, California law to govern competing choice of law interests, admitting the court's conclusion that the parties anticipated a defense in California, notwithstanding that the insured was domiciled in Oregon and that the policy was issued there. AH points to the court's further statements that, quote, this conclusion is troubling because, if taken to its logical extreme, it indicates that a policy might be interpreted according to different bodies of law, depending on where each defense pursuant to the policy was performed. However, the court in James River failed to consider the holding of another case here, that a liability insurance policy issued on a nationwide basis may be construed in accordance with the law of the jurisdiction in which a particular claim arises. Parties to an insurance contract understand this. If it pops up in a particular state, you understand as a party with that, that it applies there, right? Moreover, as evidenced by the decisions, Frontier and Downey Venture, as well as numerous decisions following them, the fact remains that the weight of California law holds that under 1646, the place of performance includes those locations where the defense obligation may be performed. And fundamentally, regardless of what James River Court's concerns were, its dicta simply cannot overcome the numerous decisions by California courts expressly concluding that the place of performance of an insurer's defense obligation may be determined by the place where it is called on to provide the agreed upon defense. So again, you see the argument that is attached there. They give another example how that comes up. They talk about this one. Likewise, this one doesn't hold up there. They also cite another here. Again, they break down, how exactly that fails and so on. So they take apart this idea that, again, they will attach multiple cases to that, just to tell you, again, they want to hammer this point home. But they're telling you, again, breaking down part B is that. I think that all makes sense there. Hey, Melissa, thank you for the 2 there. And the fist bump. Thank you. Give me one drink here. I need a drink. So part C, even applying Civil Code 2860, New York Marines reservation of rights did not create a conflict, giving rise to the right of independent counsel. Again, they're just destroying this idea. In addition to her choice of law arguments, Heard's opposition again insists that New York Marines' rights of reservation letter did enumerate a conflict-creating basis for denying coverage, since it implicitly references Insurance Code 533. As an initial matter, AH predicates this argument on a quotation of her own allegation, that New York Marine reserved a right to deny coverage on the ground that AH behaved intentionally. But New York Marine's reservation simply stated the unremarkable and legally correct proposition, that to the extent that California law does not permit an insurer to indemnify the insured, no indemnity can be provided. Makes sense, right? In turn, as California law holds, and as this court previously correctly concluded, a reservation of rights letter only creates an actual conflict of interest where it expressly cites a specific provision or exclusion in the policy. Accordingly, as New York Marine's motion explained at length, and this court has also previously concluded, New York Marine's reservation is nothing more than a general reservation of rights, since it does not cite any specific conduct-based exclusions in its policy. Heard self-serving recharacterization. So again, they call her out nicely, but they still call her out. They're like, yeah, your self-serving recharacterization of what we were saying. So when you go in, you redefine it like, how they redefine everything, I suppose. Whether that's relationships, whether that's the definition of, I don't know, medical proof, or what a freaking letter says. It actually says does not alter the fact that it does not specifically reserve rights on any particular exclusion and consequently constitutes only a general reservation of rights, which does not give rise to a conflict of interest requiring the appointment of independent counsel, even under California law. The opposition further attempts to recharacterize the nature of New York Marine's reservations by asserting that New York Marine concedes that it asserted a special provision and argued that this claimed distinction renders inopposite the relevant California case law cited in the moving papers, as well as courts' prior analysis. But again, this argument fails to focus the analysis on the correct question, as observed by New York Marine's motion 3513, I almost said just 13, provides that a law established for a public reason cannot be contravened by a private agreement. In turn, the statutory preclusion against the indemnification of willful acts set forth in 533 reflects the public policy of state of California to discourage willful torts. Consequently, 533, precluding insurers from indemnifying insured for a willful act cannot be waived as a matter of California law. So you understand what this is saying here, right? You did it on purpose. Actual malice. Remember those words. Yeah. When you do something on purpose, that is part of, again, the California law. And therefore, every general reservation of rights letter necessarily implied references that position. The opposition decides two decisions as standing for the proposition that Insurance Code 533 may be waived. However, the first is an unpublished opinion, which under Ninth Circuit Rule 36.3 may not be cited unless relevant as the law of the case. Nothing applies there. So you see, so they give application of law. So again, here's yet another example where they're like, yeah, here's the problem though. You have specific instances where that comes up. None of this goes in. The second, so they give another one, only specifically addresses the question of whether Insurance Code 533 is unwaivable fundamental policy before concluding that it can be waived, pointing to a single, then 31-year-old case. However, as more recent decisions accurately observe, this case, Tomerlin's holding was predicated on misrepresentations made by the insurer to the insured, resulting in estoppel. Consequently, the weight of current precedent holds that the 533 reflects a fundamental policy of California that may not be waived. So they go through, telling you how that sets up. They're talking about with it and so on. Accordingly, as addressed, a New York Marine's motion, a general reservation cannot create a conflict of interest within the meaning of Civil Code 2860. So they go through, reservation of right, which expressly cites 533, 1668 did not create conflict requiring independent counsel. Reservation expressly citing 533 did not create conflict requiring independent counsel. So again, what she's trying to say is I brought in my own people. I can do whatever the fuck I want, and you're going to pay for it. When you see them again tearing it down. D, since New York Marine appointment of Virginia Defense Counsel did not create a tripartite relationship, she was not entitled to independent counsel. Under California law, where a tripartite relationship is not formed between the insurer, insured, and defense counsel, no right to independent counsel is triggered. Endurance, which defended, this is endurance, by the way, versus, so endurance, which defended the insured under a reservation of rights expressly asserting in intentional acts defense, never appointed counsel to defend its insured, instead permitting the insured to continue using the defense counsel whom they had already retained before its tender. Accordingly, After the insured brought suit against Endurance, it argued that no conflict of interest arose under Section 2860 in the absence of tripartite relationship, in that the insureds first retained their chosen existing counsel in the action. They have a bankruptcy here, an underlying action, and Endurance never selected different counsel, thus rejecting the insured's claim that Endurance had breached its obligation to them. The court agreed with their analysis and that the insured cannot show that they did not have their own counsel. They were entitled to independent counsel. As noted above, under Virginia law, defense counsel only represented AH, no one else there. No tripartite relationship ever existed between AH, retained defense counsel, and New York Marine. So if you don't understand that, again, tripartite, that means, serving. You can see the triangle here. Again, AH, retained defense counsel, and the insurer. They're like, no, that's not how it plays. What's up, Cynthia? Thanks for the super chat. I don't know if this is going to trial, but I would love to. Yeah, I think it would be fun. There are dates set aside for this. And again, you've got to remember, this is aiming specifically at the counterclaim. You still have other portions of this moving forward, and there's a lot of money on the line. If AH can, it's a balancing of how much money you spend versus in the fight. We're talking about 7 figures here that are on the line. She's already invested. And beyond that, her being told no, I think really bothers her. When insurance companies decide to throw down, though, again, a lot of them have money. They can throw down. They specifically, we're talking about a place that pays for lawyers. Just like we saw AH's counsel. Remember, that was underwritten by someone else. She didn't underwrite it. So you're challenging the very people that pay for your lawyers, which, yeah, about that. That is one of the reasons they exist. So as noted above, under Virginia law, again, tripartite, we explained. Consequently, the content of New York Marine's reservation of rights letter is ultimately irrelevant, since, as California law establishes, in the absence of tripartite relationship, no conflict of interest giving rise to a right to independent counsel could exist. Therefore, as in Endurance, AH was not entitled to independent counsel, even if the letter implied reference to 533 would have otherwise have created a conflict triggering right to independent counsel if the litigation had been venued in a state which does recognize the existence of tripartite relationship. Also, so again, they're like, it doesn't even matter what you're arguing here, because Virginia they don't even accept the idea that this exists. They just danced around it. They have laws that don't dance around. That's not the right word. They have laws that answer this without expressly going into this, like other places have. So again, you have no conflict arising. Also, with failing to withstand analysis is AH's extensive argument that a reservation of rights on the basis of Insurance Code 533, whether express or implied, necessarily triggers a right to independent counsel, because the claims against her necessarily raise the question of whether her conduct was intentional or willful, and therefore New York Marine was not entitled to control the defense. However, under Virginia law, an insurer does not have the right to control an insured's defense. So again, they can't control it. They're just saying they don't. A lawyer shall not permit a person who recommends, employs, or pays them to render legal services for another to direct or regulate their professional judgment in rendering such legal services. So again, they're not puppeteering these people; they're paying for them, which is a huge difference. So they explain that the professional judgment of a lawyer should be exercised within the bounds of the law solely for the benefit of the client and free of compromising influences and loyalties. Neither personal interests of the clients, nor the desire of third party or persons should be presented to elude loyalty to the client, because New York Marine had no right to control the defense under Virginia law, and because, as the court has previously concluded, again, that goes to it, under Virginia law and ethical rules entitling her to independent counsel, and they give their statement on that. So E, Actually, we're rolling through this pretty well. We've already covered 20 freaking pages. We've done it really good. I'm trying to stay focused. Focus. Okay, here we go. E. New York Marine acts subsequent to AH's creation of its proffered defense do not create an alternative basis for the appointment of independent counsel. So her opposition also illogically argues that New York Marine's filing of the present litigation itself gives rise to conflict of interest, requiring the appointment of independent counsel. I mean, drink that in. I want to read you this again, okay? They argue that them filing this litigation gave rise to conflict of interest. Okay. New York Marine extended a defense in the underlying action to AH through, again, McAvoy, October 1st, 2019. AH admits that she refused to fully accept the defense provided by New York Marine through McAvoy's firm, and that McAvoy's firm withdrew from the defense no later than November 20th, 2020. This action was filed July 11th, 2022. You see here, one of those things is not like the other, right? Oh, you see the issue here, yeah? You see it in the dates. Wait a minute. How exactly does that work out? You file an action July the 11th, 2022. They withdrew November 20th, 2020. Nevertheless, her counterclaim and opposition both established that her true position is that New York Marine breached the terms of the policy from the onset, and its doing so excused her from fulfilling her obligations under the policy and allowed her to refuse to accept the defense provided by New York Marine. They note here, asserting that New York Marine's refusal to agree to defend AH through independent counsel made it impossible for her to fully accept the defense provided by New York Marine. That's the argument within. And again, arguing that because New York Marine did not provide independent counsel, she was not required to accept the defense provided, and that New York Marine's appointment of counsel did not discharge its duty to defend. So again, write me that check, fool. However, since AH was not entitled to independent counsel, she was not entitled to refuse to accept the defense provided by New York Marine, and thus she breached her obligations under the policy by doing so. And she admitted to it too. That's the thing here. Her argument, she can't argue, I didn't do these things. She has to argue it differently. I mean, isn't that interesting there? What's up, Bessie? No matter how much money she doesn't have to do this, it doesn't matter. She's guilty, narcissistic till the end. This one, yeah, actually, that's something that you see. Even when it would be beneficial for a party to step away from something like this, even when you should disconnect, you should just walk away. It won't. See, the best thing for AH to have done through all of this is just to go silent. Go quiet, let this stuff blow over. But instead, it's still moving. And I mean, think about where we are now. We're in March. We're talking about another thing that attaches to her name in March. When you combine all the other stuff that people that are indeed attached to her, I'm not talking about just weirdos and simps. I'm talking about, again, mainstream media. You can see PR moves still. You can see them. They're transparent. You see politicians, again, trying to go in, trying to change up things. Again, you know how that stuff comes up. Yeah. The smart thing would have been to detach and make everything go away, to quickly remedy issues like this. But again, narcissists can't do it. So although New York Marine was not entitled to control the defense, under both Virginia law and New York Marine's policy, it was still entitled to appoint defense counsel. There's a big difference there too. They're not talking about controlling the defense. They're not telling them how to provide a case, but they're providing the best case possible. She went with yes men. I mean, when you look at Elaine, Let's be real about that for a second. Look at what she presented in the courtroom. To me, and a lot of others, I've read this opinion many times. She just regurgitated this tale of AHs. She went on the attack in ways that they would double and triple down on this damaging narrative, and she was woefully underprepared for what came up in that courtroom. Woefully underprepared. The people that they decided, remember, their counsel brings in all of their specialists here, their expert witnesses. So they decided on witnesses that, first of all, you got to be honest about a few things. First of all, you want people that don't look like wackos. And they did. They looked out of their gourd. They looked hateful sometimes or crazy. I mean, like Dr. Spiegel, doing his thing with his mouth. I mean, God, when you think about those people, you don't focus on their arguments. You focus on these externals first. Then if you focus on the internals of some of the arguments, like when you had her a person talking about her mental state of mind, the examinations, the person that was discussing that came off as if they hate men. Not that they represented anyone, but they seemed like they hated men. I mean, that was a conclusion many people came to, that she just out and out did not like men, because she always brought up, aggressor men, aggrieved women. Always. She went with that. Her wording was always with that too. She should have known better than to adopt the language. Again, people like that feel like they're going to somehow speak to the women in the jury. What they don't understand with that is that most women have men in their lives that matter to them. Their fathers, their sons, their friends, sometimes role models, and vice versa. When you have somebody that's just an overt sexist and they present that, you got a real problem. And that was, again, that is with her picking out people, at least in the case of Elaine, for sure. I mean, I disagree with many people that say that Rottenborn was a great lawyer. There are people out there that say, yeah, compared to Elaine, Rottenborn was a great lawyer. Compared to other people, just ignore who's on the stand or anything else. Think of it as a lawyer. What do? You attack, you dismantle. That's the way AH's argument. It was just taken apart at the seams. There were points in that case where they could have taken apart some of JD's testimony, whether it's true or not. And they did that at one time. They did it with text messages. And then they bafflingly put her back on the stand and they undid any progress that they had. It doesn't matter if they misrepresent. When I'm making that argument, again, if she was going to bring in people that were going to win a case versus yes men, that's what New York Marine wanted. But every time lawyers would do something that she didn't like, if they couldn't get the case dismissed because of X or Y, you would hear about lawyer replacement. She considered them inept when they couldn't get the case moved to California, for example. Oh man, well, okay, that's just a shot and a miss. They tried 4 different ways of doing so. 4 different ways. They had some success in trimming down some of the items that came up in the Washington Post article. They actually managed to do some of that. They did have some success, not dismissal, but again, they limited the scope, making it much more difficult to present what they did. And every time somebody did that, even again, it was just like, nah, let's go with somebody else. When you have a lawyer, if I pick up a lawyer and we don't have an immediate success, I'm gonna hire the best counsel that I can. I'm going to hire somebody that's good at what they do. And I know they're good at what they do. They can explain to me how everything's moving forward, but you have to, when you believe in that, again, there are exceptions like, if your lawyer, for example, let's just say, they leak 10 years of text messages, you should fire them. That happened, that's a problem. But if they can't get one thing, again, some Hail Mary move, they can't get that worked out. Yeah. And again, I think that's the issue here. You had the conflict. knew what was best for her in her case. Again, that was somebody, she figured this was an unlosable case. She heard that again and again. She bought into it. She bought into the press of #MeToo. She bought into the press of, again, this tidal wave that's going forward. And she figured because she had a lockdown on the press, she had a lockdown on social media for a while, this was an unlosable case for her. And to an extent, she was right. It was, I would say, more of it would have been almost unlosable. But it definitely didn't look, it looked winnable to a degree, but the odds, I mean, these are almost unlosable cases. If you played this thing right, with all the things they got away with things like they made make this decision for all women. They got away with stuff like that at the end, like with stamps of approval like that during a case. How do you lose something like that? Well, you lose it by being an idiot, not going with the counsel, the best ones that would have made your point. And could see that again. They didn't have a counsel that represented them. They had the counsel they thought best represented Heard, that they were paying for. So Heard's refusal to accept the defense breached her obligations again and relieved New York Marine of any further obligation to defend her. The opposition quotes a generalized statement of Safeco versus Superior Court, which, within the framework of California law, explained that the purpose of no action clause is protecting the insurer's right to control the defense. But that general characterization did not consider the fact that under Virginia law and ethical rules, New York Marine could not control the defense, but still had the right to appoint. Again, control versus appoint. Virginia Defense Counsel, who would necessarily operate subject to all relevant, applicable Virginia legal and ethical rules governing their conduct. Thus, no action clause. Could you imagine, by the way, if the thought was that McAvoy was an agent of the insurance company? I mean, that's how that's presented, right? He's an agent of the insurance company. He's not representing me. He's representing them. Could you imagine that mentality? That mentality, it permeated that portion of the case. You could see it again. You could see them written out of documentation and more. Could you imagine how that would work against your, it may, again, it may fulfill some kind of personal need, but it doesn't fulfill your legal needs. Yes, people patting you on the head and telling you you're the greatest thing since sliced bread, maybe that does fulfill some kind of personal need. But when you get out there and you need to win, yeah, undermining these people, treating them like they were agents of, I mean, this train wreck that we saw, what we're hearing through all of this, and I believe this, is that it was preventable. I think could have won that case if she would have had cutthroats, because again, it's an uphill climb for somebody like JD. These things, he would have won. In my mind, he had the court of public opinion on lockdown, because the court of public opinion, like in the retellings now, they're like, oh, these influencers, they went out and they shaped the mindset of, and it's like, nah, idiot. They presented documentation, because the documentation has always been there. Like, we go through this entire document. Okay, we skip a few paragraphs, but we go through it, and you make up your mind. If you disagree with me, that's your prerogative. But, if you want to go out and pick up snippets from the media, they're not going to tell you anything about it. And remember, they locked down all information on this period. So, court of public opinion, I felt like it had swayed. In the beginning, it was with AH because, listen and believe is a poison. When you have somebody, when I say that, I mean, you're not, again, you're not talking about empathy and saying, oh man, you've been through something horrible. We're talking about pointing the finger and burning someone's life down. That is a poison. But at the times that she launched her claims, that poison, and even now, that poison is just, it's socially acceptable. Anybody that makes a claim, it burns people's lives to the ground. But as far as court action, but anyway, thus, no action clause would properly operate to protect that interest without also permitting New York Marine to control the defense under Virginia law. It follows rather that New York Marine's motion reference to the no action clause does not retroactively create a conflict, giving AH the right to independent counsel. However, by AH having admittedly previously refused to accept the counsels appointed by New York Marine and allegedly incurring other defense costs as a result, it follows that she is in breach of New York Marine's policy no action clause. So she's admitting, oops, whoopsie, you're admitting fault. So she's admitted fault under this. Like that's her screw up. She comes in and she says, yeah, I did X, Y, and Z. Whoopsie, you just dig a hole. Dig it deeper, baby. Bessie thinks with two tucks. Stinky brown starfish. She won what? What's that line? Oh, what the heck? Yeah, I was like, what does that mean? I see where you fudged it up. I was like, wait, what? Moreover, the no action clause was never explicitly raised by New York Marine in its reservation of rights letter and has become relevant upon AH's own breach of her policy, having predicated both her defense and her amended counterclaim on the proposition that New York Marine was in breach of its obligations from the onset, forcing her to take unilateral action to repudiate its proffer of a defense through the same counsel she originally selected. She cannot now argue that New York Marine's subsequent act of filing this suit or its reference in the motion to the New York Marine policy's no action clause retroactively justifies her initial breach. It thus follows that AH cannot create a conflict of interest based on anything occurring in the present litigation, because by the time this was filed, she had already repudiated her obligations under the policy by refusing to accept the defense proffered by New York Marine. I mean, that's a terrible thing to say. I mean, really, when you go through that, that's probably one of the worst arguments that she's made out of any of it. She admits to breach of contract. She admits to issues brought about, but then she's saying, well, they filed a litigation. That's what damaged me. And it's like, that doesn't even make sense. Fallen Hero, thanks for the 5 there. Play stupid games, win stupid prizes. Indeed. Indeed. And Steph B, thank you for the 5 gifted memberships. Thank you. I appreciate that. I love watching them rain down. Like I say, that's awesome. Thank you. So, Heard's bad faith claim must be dismissed. It is well established in California that without a breach of the insurance contract, there can be no breach of the implied covenant of good faith and fair dealing. In an attempt to avoid application of this principle here, Heard cites 4 cases which he incorrectly contends support the position that a claim for bad faith may exist in the absence of claim for breach of contract. However, all of those decisions deal with claims involving an insurer's failure to investigate or render a coverage determinations, allegations that she didn't make. Furthermore, her opposition mischaracterizes those cases. Specifically, she quotes, McMillan, stating that, quote, an insurance company could be liable to its to its insured for tortious bad faith, despite the fact that the insured contract does not provide for coverage. However, what McMillan actually says is, we also continue to believe that there may be unusual circumstances, notice that they underline that, in which an insurance company could be held liable to its insured for tortious bad faith, despite the fact that the insurance contract did not provide for coverage. McMillan nonetheless went on to follow the well-established law that the insured's bad faith claim did not survive in the absence of a contractual breach by the insurer. Oh, whoopsie. Whoopsie. Oh, man. So the case that she cited there, it brought up the idea of breach by the insurer, something that she admitted to. So her own case law that she cites, her own legal precedents, they actually rule against her in some ways. Isn't that lovely, right? What's up, Bessie? Thanks for the 2. Tug's new name for Gel. There you go. Tug Stinkly Wrinkly Starfish. Gross. Makes more sense, but still gross. All right. So, citing Love, it says, in stating that our conclusion that a bad faith claim cannot be made unless policy benefits are due is in accord with the policy in which the duty of the good faith is rooted, and holding that because there was no breach of the express provisions of the contract or other interference with the interests of the policy was designed to protect, no claim for breach of covenant arises. Similarly, they give with this one, simply is not relevant as the insurer was found liable for breach of the policy. It simply did not challenge the determination that it breached the insurance policy. New York Marine's motion to strike is meritorious, they note, and Heard's opposition admits facts establishing that it should be granted. They admit fault, as they say. This is, I believe this is their last argument in this. So Heard's opposition to New York Marines, and then we'll go over the timeline that all of this takes place. Alternative motion to strike again asserts that New York Marine did reserve rights to deny coverage on the ground that AH behaved intentionally, and concedes that it did. Marine, they made no such concession, they say. And AH's characterization of the content of New York Marine's reservation of rights letter is again a misstatement of what the letter actually states. Equally notable is the opposition's admission that the content of paragraphs 7 through 16 and the amended counterclaim, there's a lot of counterclaim, by the way. When you go through counterclaims, there are a lot of paragraphs, just to say. I mean, when you read through them, they're covering contractual items. Like this gives you an idea of how this works. Let me just show you something real fast. So when they reference that, if you're wondering, you can always tell what's referenced, even if you haven't really read it, normally by what it covers. But what they're talking about here, you can see it. They're talking about she thought, well, this is going to be a great insurance company. They have such a good reputation. She believed, she talks about they were part of ProSide at one time. She believed that because of that, well, these certain things, they would exist in that, and so on. So you can see this is all about, customer focused, integrity, respect, accountability. We as experts. So you see what they're calling out here. They're calling out the fact that, well, the way that she puts this together, about that. So I'll show you again. Again, you can always tell what they're discussing with it, but I think it's important sometimes to bring it up like that too. Rhea, thanks for the 5. When AH was filmed walking around TJ Maxx, was she looking for Monograph? Oh my God, I never thought about that. Yeah. So if you did that, Monograph, who's suing Ricada Law, like in his first his 2019 litigation, his address, according to to Mr. Medicare and Nick Rekieta at the time was in a TJ Maxx. That's where it was located. So AH, when she was photographed in TJ Maxx, she wasn't buying clothes. She was just looking for monograph. That's hilarious. Chungy Show, thanks for 5. How late? Going because missing some fun treats from the courtroom. Right now, I'm a little speechless. Doesn't happen often. How late am I going? I don't know. I'm wondering what's going on with that now. You've got me wondering. That's funny, though. I'll check it out in a minute. Let's finish this one real quick. When we get to the timeline, I'll look at it too. So, paragraph 7 through 16, minute counterclaim, in which he seeks to strike recite marketing representation made by New York Marine's former parent entities. New York Marine motion cites well-established California law holding that market puffery, that's what they're calling it, market puffery, is not generally actionable. That when admissible, marketing statements are only relevant to address the party's expectation as to an ambiguous policy provision. So when she was like, they promised me great customer service, they promised me that. No. You can't bring them up for that and then say, I don't feel like I got represented. What you bring up is something where they mislead you. It's got to be something direct. That's what they're telling you. In response, the opposition asserts that New York Marine argues that extrinsic evidence is only relevant when policy language is facially ambiguous. That is not correct. In support, AH's opposition cites 2 cases. You can see them here, which she contends support her argument that alternative motion to strike should be denied. However, New York Marine's argument says nothing about facial ambiguity. Rather, it contends broadly that such materials are admissible only with respect to the interpretation of an ambiguous policy provision. Thus, the cited cases add nothing to the analysis. More fundamentally, however, as observed in New York Marine's motion, as is undisputed in the opposition, AH's amended counterclaim does not allege any ambiguity in the policy or CPL endorsement, facial or otherwise, nor does she contend that she relied upon any of those statements in evaluating and obtaining New York Marine policy, nor do her amended answers or the affirmative defenses therein. Thus, the statement alleges that in paragraphs 7 through 16 of the amended counterclaim cannot be material. Likewise, because, again, as noted and as undisputed by the opposition, at least some of the allegations appear calculated to improperly place the issue of New York Marine's wealth before the jury. Her argument that the court may deny a motion to strike without an adequate showing of prejudice also does not suffice to defeat the motion. So they're saying, yeah, she's going to go after us for things that, well, they're not there. They don't exist. That's not right. That's not part of it. So the conclusion, for these reasons, of course, we want you to, for these reasons here, New York Marine respectfully that the court dismiss the amended counterclaim without leave to amend, or in the alternative, grant its motion to strike the alleged paragraphs. So those paragraphs 7 to 16 and 25 therein for a more definitive statement. So again, they're like, you need to strike this claim. If you don't strike this claim, you need to strike the stuff that that talks about how we laid this out, that makes claims that really fundamentally they're not correct. And yeah. So we won't find out about this right off the bat, by the way. We won't find out. Here, give me 1 second. I'm going to lock this on. There was a date attached to this. Again, there will be a hearing. Whoops, wrong one. I've got like an army of them open because where I was showing you before. Give me 1 second. It's this one. So there's a date on this where we get to find out how exactly this gets to be addressed. March 13th, 2023. Now, there are a lot of dates that are coming up, depending on how this thing plays. And it may play, we have no idea how to play. Let's just say that. If we look at the schedule that was laid out, and again, props to DUI guy posting this, I'm actually going to show it off of his Twitter just so I can give him a little bit of love on that because he's done a good job covering this. Like I said, Laura B does a great job. I think there are plenty of people that do. I don't mean to leave out anyone, Andre, for example. I mean, there's plenty of good people that talk about this stuff, plenty of them out there. I just, there are specific people that have focused on this and they've done a good job with focusing. I catch a DUI guy laying out certain things, and Laura B will, usually she'll do a read through, go through specific items, and I mean she has a good fundamental grasp on these and other cases. I'm Tugs, wrinkly, stinky, brown starfish, gross gill. Thank you for two. Say my name and revel in it. If you laugh, you lose. What if I say that? I think I laugh at most things. Some people are like, man, are you high or something? Yeah, I'm high on life, baby. That's why I like to laugh at stuff. I get that sometimes. You laugh so much. Are you high or something? No, man. I just find life funny. I find all this stuff funny. All right, so let's check this out. So here's the dates on this. All right. So again, in notes, no further amendments are allowed without Rule 16 motion. Now going forward, we'll have post-mediation. So they'll have post-mediation status conference. They'll have that conference August the 3rd. Now, in order to have that, they'll make arrangements so that mediation, it'll be completed by July 31st. That's assuming everything keeps moving forward. We don't know how that counterclaim will actually play into things. So, we're gonna see how everything puts together. Right? We'll see the makeup of this thing, but we still have a bunch of things moving forward. Again, we don't know the details of this thing yet. It's going to be fascinating. I kind of want AH's counterclaim to move forward. And you know why I want that in a way? Because I want New York Marine to be motivated, to be really motivated. Because if they're really motivated, that's when you're going to get some amazing stuff that's going to come out through discovery. I think that's where it really, you're going to see some fun times. What's up, Muffin Rando? Thanks for 5 free hashtag Tum Sip sprinkles, y'all. She shouldn't be ghosted or banned. You're saying free her. She should, if there's a banning thing, there shouldn't be. I'll look at ban. Unfortunately, this is one of the stupid things that YouTube has. Just by the way, if somebody accidentally mutes or you do get banned for some reason that is not approved or righted, if I go in and I go and look that up, it doesn't list bans by any. There's no. It doesn't have a way to sort them. So it doesn't have them sorted by when. It doesn't have them sorted by alphabetical name. It's just this huge hodgepodge of a mess. So I'll look, though. A post-mediation status conference is set August 3rd, 2023, with mediation to be completed by January 31st. Parties will make arrangements so that the mediation can be completed by July 31st. Joint report filed with the court by noon on August the 1st. So, got the meeting the 31st of July. You have, give me one second, I clear my throat. You have the filing August the 1st, and then you have your post-mediation status conference for the 3rd. Now, going into discovery, all regular discovery will be completed by August 28th, 2023. By completed, and note, the court means that said discovery requests must be served sufficiently early such that a motion to compel, if necessary, if you have to force somebody to actually comply with the rules, they can be filed, they can be heard and complied with before the cutoff date. So again, that all laid down, and you may get some fascinating stuff in discovery. I'm not sure what exactly can be brought into that. That will be fascinating because, again, you see the argument being made by New York Marine. What exactly can McAvoy say? What exactly can other people say? What about, I don't know, Elaine? Elaine, while she still may be able to milk cloud out of that loss, she was thrown under the bus by Amber Heard. And again, I believe that she was I believe that she was to blame for a lot of this stuff. But, at the same time, if you hire an idiot, what do you expect? And part of this, part of the loss of a case, you have to work with what you have there. And Elaine is the perfect example of working within the confines of the case. She worked with the story that AH gave, and it is absurdity personified. There are so many things that are misrepresentations too. Like when they tried to bring in so-called medical proof, and you saw that got shut down. They were going to bring in ear, nose, and throat specialists saying, oh, well, I talked to an ear, nose, and throat specialist. There was damage in my nose. Yeah, you can get damage to your nose. Deviated septum, for example, that is one of the most overly applied thing. And ENTs, they do that all the time because that is their bread and butter. They tell the people all the time. Now that happens as well. You can be born with all types of issues with that. I had one from falling off a slide once. Actually, I was a little kid and I did a nosedive off of a slide into concrete. That wasn't fun. And I busted my nose again 2 other times. So yeah, I had that. But I've known multiple people that have been given that as a faulty thing. Drugs do that to you a lot too. You want to talk about something that will do damage to your inner lining? Yeah, cocaine. That will mess you up there. And well, yeah, I'm going to say, considering someone's ID was out on a table and so many other things there, that maybe, just maybe, somebody might have had a little bit of problem. I'm not talking allergies there, although allergies can cause damage too. But anyway, you could have some really interesting discovery items that come up. Like I said, I'm curious who will come in there. Also, all expert discovery. Now, the expert discovery, that will be curious as well. And again, we've had access to quite a few filings. Oh my God. I'm waiting. I'm just like, because I can't believe this stuff still goes on. A lot of people have no idea that this is out there. They have no idea that this stuff is moving forward still. They think everything's said and done, and the biggest trash fire is still going on. It's amazing. It is absolutely amazing. But the parties are to meet and agree in writing as to when initial expert reports will be exchanged and rebuttal experts reported thereafter. The last day for the courts to hear any motions, October 30th, 2023. And then you have your pretrial conference, November 30th, 2023. Jury trial, December 12th, 2023. Now, that December 12th, 2023 date is very important. Very important because if this actually happens, this is going to be this will definitely be the end of AH's career. I mean, no, like it's already done, but there will be no disputing that it will end. Why? Well, if you look up Aquaman, you look up when Aquaman 2 is going to end up releasing, you'll find an interesting thing about that. What is that? Oh yeah, Christmas. This is aimed less than 2 weeks away from that. So you're talking about some real damage to Aquaman potentially happening. Hey, Nancy, thanks for that. Hey, Tug, is there anywhere we can catch all your live streams from the Depp versus Heard trial, or do you only cover certain days? Now, I didn't cover the first week, but after that I did. I'll put them all back up after a bit, but the reason I took them down, there was an active, remember when Chris Boozy was going on his active flagging spree? Yeah, I removed that stuff during that time. I didn't remove it as in, delete it. I privated it. But the first week of it is on Ricada Law's channel. Okay, let me pull up one other thing. I want to show you this. Over the first week over there. And I decided I managed to, after that, I managed to secure time off. And when I secured time off, I was like, oh man, I'm going to cover this myself afterwards. So I thought at first, though, I wasn't going to be able to cover the entire trial. That's one of the reasons, like, I switched off. I enjoyed covering with Recato Law too. It was fun. He does, he does panels. Like for me, I like solo coverage. I thought about doing some panel interviewing a little bit though. I'm going to catch up the Manson case, for example. I'm going to talk to some people on that. But by and large, I mean, it was just a different type of coverage. But man, I did enjoy it. I thought it was fun. But you can catch that first week, and I'll add all the other ones back in. I'll add them a few at a time. I'm going to start doing that. Maybe next week I'll do that. I'm looking for one post really fast. I'm trying to see if it still exists. Warner is locked in to December 25th. I don't think they can undo December 25th. I think that they are stuck with that date. And the reason I think, like, again, the reason I'm bringing this up for Aquaman is because there's no way, if this stuff comes up, that it's not going to do real damage to that. Now, if you look, the reason I think it's locked in, if you look, James Wan, for example, here's James Wan's post on August 24th, 2022. So, I mean, we're talking about a long time locking in. Now, remember, they had already moved the movie around multiple times before this. They had already decided that they were, they were going to try to get it as far away from the trial. After they moved it, they decided to move it again. Plus, they moved other things. But remember, they've brought in new management since then. Brand new management. Yeah, I'm going to get Colonel Kurtz. Probably the Manson cases. I'm going to get them too. I like both of them. I think they do a good job with it. I'm going to let... what's fascinating about the Manson thing, just really fast? You notice until Ashley Smith Lunn decided to recant, that these mainstream media shills, the puff piecers, the tech journalists, the Cat 10 bars and more, they didn't really give a shit about that case. After that happened, though, they had to come in and they got to circle the wagons, do the whataboutism, denounce the YouTubers that cover that. You notice that? They didn't give a shit because anytime there's a liar or an abuser that gets exposed, female, man, those false accusers, they got to circle the wagons. They got to pull out the whataboutism, and they got to start saying, what about them YouTubers? What about this? What about that? And it's like, yeah, transparency. But anyway, so James Wan, he locked in that date himself. And the hype around that date, the 25th, he's hyped it as, oh man, we put out the first Aquaman then. That's the perfect time for me because I'm superstitious. That'll be the perfect way to drop it. And I think they're locked in because of new management. This is going to be the last movie that's from the old guard, as it were. They want to turn the page. They want to turn to something new. Well, to do that, they got to get rid of Aquaman. They want to move forward with a new plan, and they expect this to fail. Now, I'll be interested in how they advertise this movie. And the advertisement, here's the problem too. If you don't know, like that trial has to scare the hell out of them too. Because typically, I mean, right now, again, we're talking about a budget of $205 million. Typically, you will double your budget on something that needs a lot of advertising, maybe even more. But typically, just say double the budget. So we'll just be nice at $400 million. If they're going to drop $200 million and then get undermined right before the trial kicks off, 2 weeks before it. So did they try to let the advertisement speak for itself? Word of mouth and more. How much money do you invest in something that if this trial goes forward, it will be like a nuclear bomb decimated? You know what Warner needs to hire? They need to hire some people with some fucking common sense. Like people that'd be like, nah, dude, have you seen this person's background? Ezra Miller, giant red flag. That guy. If you're going to keep him for the Flash, by the way, maybe don't make him your poster boy going forward, because who knows what's going to happen next. And they've been, with all of new management statements about how they do this, that, the other, they've embraced him, and they've embraced him corporately. You can tell you can tell there's a problem behind the scenes with AH and Jason Momoa because of this, but you can also see there's a corporate move to do that. You had Jason Momoa being like, yeah, The Flash, Ezra Miller's great there. He gave an endorsement, because that's smart business. I mean, I don't fault him for that. I would do it myself, I mean, again, you've got multi-million dollars. You're endorsing the product there and the person on it. But you notice he didn't do that for AH. Fascinating. No public love getting there. In fact, it was the opposite. He picked up JD on Instagram. I mean, during a trial, there's something going on, but they're locked in. I don't know how they get away from this. That's going to be a nightmare for them. And I think that is a potential nightmare that will cost them a multi-billion-dollar enterprise. And they know it too. They absolutely know it. Hey, Nancy, thanks for the 5 there. If you do cover the Manson trial, I think the dream team would be you, Ricada, and Andrea Burkhart. Yeah, I don't know if I'll cover with lawyers. Like I like sometimes here's what I mean by that. I like to cover by myself and maybe talk with some folks. Like I don't like to be there all the time. I don't like panels. Like if it's a small panel, I do okay. But man, if you get one of those large panels where you have a lot of people, it's just not my element. I don't enjoy it particularly. And if I'm going to watch a trial and participate, I like to hear what goes on. And the larger the group, like Ricada does a damn fine job of covering stuff. Like he's great at it. Andrea does a fine job. She's smart. She's funny with stuff. She does a great job with things. And there are a lot of lawyers. Like I say, I like DUI guy. I think he's funny. I like his sense of humor. It's dry. It catches you off guard. It's there, and I don't. That's the type of humor that I really like. I like humor that just it sneaks in there. I really like that. Plus, you have a knowledgeable lawyer in that. I like James from court, man. I mean, that guy is a good dude too. He's good. He knows what he's talking about. He's also he's in it to win it. I'm going to say. As far as the crazies like the tech writers and stuff that have joined in and have attacked. I mean, he's one of those people that has made sure. Go with it. Oh man. Oh my God. I'm reading some of the quartering stuff. Oh Lord. Like somebody told me to look at the quarterings things. Holy crap. He's going to do an apology video in a few days for this. He made a statement earlier. Oh my God. I'm not going to, I don't know if I want to show all the words. Well, fuck it. Let me see. Oh my Lord. Yeah, maybe you should read those yourself. He's going after right-wing commentators. He's talking about how they love the and they're having a breakdown. He's going after Cernovich, which I'm not. I don't consider. Again, I'm trying to make this clear. I don't consider myself. I definitely. I believe in freedom of speech. I own firearms. I also, I believe that life, liberty, and the pursuit of happiness involves you being able to get into your freaking doctor and get mental health, professional care. And I think you should have it, irregardless of whatever, and it needs to work out. That's a part, perfect world. There isn't a party line, but Lord, it's been funny to watch this insanity break off lately. But Cernovich, he's been on this kick lately of calling. He went after that show Tulsa King at first, and he called it quote unquote woke. You can call it whatever you want, by the way. It's just a catchphrase, woke. It means depending on what side of the fence you're on, sometimes we all understand what the shorthand is supposed to mean, but that freaking show is not. It's not what people are trying to make it out to be. That show is a very good show. It is as far from politically assertive. I mean, it's so ridiculous to assume that. What's up, John? Thanks for the 5. Somebody in chat said Ricardo wants you on live for Monty stuff. What, tonight? Did he say something about it tonight? I didn't. Give me a second. Let me pull up chat. My phone just died. I mean, yeah. I mean, that would be. Like I said, I like streaming with Ricardo. I'm weird about friends online. Okay, I'm really you see how like Camelot and like Nick are like good pals and stuff. I'm not that. I'm not that personable, you know. But I like Nick. Like he's good people. I consider him a friend, even though we don't talk very much and stuff. And I enjoy his entertainment. I think like he's a fun person to like live stream with and goof off. You know, I'm an introvert, you know. I keep a handful of friends in life, and that's about it. I go quality, not quantity. But yeah, Nick, I would consider for sure. Yellow Flash and stuff like that. But yeah, I think it would be fun to talk about with this stuff. But yeah, anyway, so they were going after Tulsa King. Now, if you haven't seen Tulsa King is a story about that's a Sylvester Stallone movie. Okay, Tulsa King is a story about a guy who spends 25 years in jail. He murdered somebody as part of the mafia. He comes out, he doesn't get what he's promised. You know, he's promised all these different things for, you know, standing up. Again, he stood up for the family for 25 years. For a murder, it wasn't really his. I mean, they explain that. I won't really ruin anything on there, but he comes out thinking, yeah, they're going to take up for me. And what they do instead is they're like, yeah, you know, we got this great place laid out for you. You know, we're talking New York mob. They're like, yeah, there's all these opportunities. We want you to go in and we want you to cultivate Tulsa. He's like, what the hell? So he comes out and he's confronted with a world that has changed. I mean, cell phones. Like, what's up? All this technology, but also words. Like he picks up a driver in the beginning, and some people were saying, I don't get their argument. His driver's a black dude, and because of certain things that come up with him, I guess some people were saying, "Oh, that's what." No, he comes in, he confronts the black driver. He's like, he calls him my gangster. You know how people call people gangsters, and Stallone's like, "I'll break your face if you keep calling me that," because you know calling somebody a gangster is a slur, you know, back when. And now when you come out, yeah, that's something. But he runs into words like triggered. You know, somebody says, "Oh man, I'm so triggered," and he doesn't understand it. He's like a fish out of water. He also goes off on a like, "Oh my god, pronoun! What the hell is this crap?" So again, I don't understand how that show. I don't even know what they're trying to do with that. It's like I understand where people get to this point where they distrust. They just heavily distrust, but that's not what that is. They also brought up Yellowstone. Yellowstone Yellowstone is another great show. Yellowstone is the Dutton Ranch. The Dutton Ranch that is standing against time. They want to stand still as this thing we call progress, modernization. It tries to eat away everything, whether that's whether that's the concrete jungle taking over, whether that's the corporate. I saw some people saying, well, it's woke because the evil corporations evil. Corporations are fucking evil. You know, most of them are. I don't even get that argument. They're also, you know, environmentalism. That's going to come up in that, of course. Of course, that's going to be a topic because that damages. They have that issue. I'm not going to ruin this, but they have an issue with tagged wolves. You know, wolves killing livestock, but they're tagged. That's a problem. There's activists that come up in there, and he ends up having had a relationship, a sexual relationship with this activist, and some people were bringing out sex again. And then there's this Native American storyline. The Native American storyline is something that you never see, and I think it needs to be told. People still live on reservations. It is a horrible thing. The Native American is treated terribly still. Like I said, I saw it with my great grandmother as a kid. For me, like, you can't tell some people, like for me, you're not gonna look at me and think, oh, Native American. But with my great grandmother, people did. And as a little kid, I saw that. And I mean, it was like, it's strange. When confronted by the culture, it very much is. It's something that people want to tuck away and pretend it doesn't exist. And there were a lot of horrible things that happened there. And bringing that up, it's not dwelling in the. It's not sitting there and trying to dwell on the past. It's saying, look at the present. Look what people are still living at, and how you. It brings up an interesting conflict for the Duttons, because the Duttons, to them, a Native American that comes in and wants to build a casino, build his tribe up, take everything back, buy all that land up. To them, they're the enemy. They're a monster. But to the Native American, the Duttons are the monster. And I don't know. I find that fascinating, because you're not in that portion. It gives something to the audience that it's a true conflict. You have to think about, of course, you're rooting for the Duttons because it's a show about them. They're it is not a show just, if you've looked at that show and you think, man, it's just about ranchers, yeah, it leaves out the part about the serial killers that they are. I mean, they kill a lot of people. It has some crazy stuff in it. Crazy stuff. It's almost over. I mean, you can check it out. I like the show, but Cernovich, my whole point in that is, for some reason lately, Cernovich has been going after shows like that, and people that are like, nah, man, that's not right. Like, you went after Jeremy from Geeks and Gamers, that was saying, dude, like, Tulsa King is not, it's not, whoa, what are you talking about, dude? And I get it. I get that people they're leery of any product. Man, I get it. I get too, if you don't want to back anything. I'm not telling you to back any projects. In fact, my stance on like a Warner or anything else. But as somebody who talks about products, unless I am openly just boycotting an entire company, like these days, I don't really do any. I try to avoid a lot of Warner products because they've been pretty nasty about it. I don't have a lot of use for Disney. It's so odd. But if I'm going to talk about something, I want to be able to tell you an honest opinion of it. I don't want to lie about it. And people all too often, they'll adopt this stance of everything is bad, unless you are willing to say that entertainment somehow ends here except for independent projects. How do you change that? How do you, there are a few problems. Again, I think you should honor legacy characters people love. I don't think you just go in and meaninglessly change things. I do think that there's plenty of open ground for brand new shows, and it can include anything. It's just like comics, man. Like I've said with independent comics, you cover whatever you want in independent comics. That's some of the best things I've seen. And when I say independent, independent film is not. It's not this tiny thing anymore. We're talking about, movies with $30-40 million or more budget. They're big time. It's not the thing of yore. But yeah, if you're going in and, the controversy, I personally think that a lot of these companies, at first, they went in to placate people, and I think it's insulting sometimes. It's like this. I saw it with, in comic books, there was a huge pushback after identity was taken from people, and it was taken and put on generic characters. Nobody wants to see themselves presented as a generic cardboard cutout or something offensive toward them. And oftentimes they'll do that, or they'll take a legacy character, let's change them for no reason, and that makes people mad because people like their legacy characters. They do. If it's something that's established, you change it up, people are going to get irritated about that. And unfortunately, it's become normalized when fans get irritated because of changes, whether that be, again, identity, sexual preference, race, whatever. It doesn't matter. People don't like to see the characters that they like changed, And when people were like, "Oh my God, what is this?" They get called terrible things, and it snowballs. It's such a strange thing, and it's been used. You can see that sometimes utilized, like Nick Fury, for example. Nick Fury, Samuel L. Jackson. That's an interesting change. It worked out. It worked out pretty well. Liked it. It was kind of awesome to watch with it. But a lot of times, changes have been used to advertise mediocre products. They'll say, "Oh man, this is the first of," and really, what they're telling you is this is a lackluster product. They have nothing to add. People get irritated. So I understand why people get annoyed. My whole point in that. But when you're going in and you're looking at, you're saying, well, this product is X or this product is Y. I can tell people haven't watched that product. Yeah. It just irritates me. Anyway, that was off the line. But all right. I think I made my point for today. That was just a random thing to throw in at the end because I was looking at the quarterings posts. If you want an interview, I don't bring them up because, every time I bring up something that includes like Nick Ricay, it gets hit because of certain words. And well, let's just say the quarterings got some of those words there to you today. That's the best way to go. So anyway, I'm going to call it a day. I'm going to go play some video games and, go check out Mike, by the way, Mike Walters. Go check out his channel. He's going live, maybe live already. Check them out. But anyway, I'm done. I will see you. Appreciate you, folks.